Good afternoon. I'm Nick Friedman. I'm a tutor in law here at the University of Oxford and also the graduate mooting coordinator. In this video, I'm going to go through some advice about how to draft legal arguments for your memorials, in the course of which I want to talk about three major themes. One, I want to introduce you to something called the ILAC method of legal argument. Two, I'm going to talk a little bit about structuring your research. And thirdly, I'm going to talk about some practical problems to do with drafting legal arguments and how to solve them. So let's begin with the ILAC method. Just as you would have learned in school to structure an essay according to an introduction, a body, and a conclusion, there's a specific way that legal arguments, and in particular memorials, need to be structured. And that is according to what is called the ILAC method. ILAC stands for Issues, Law, Application, and Conclusion. So let's go through this step by step. We begin by setting out the issues, and that means translating real-world facts into legal facts. We take a problem from life and we turn it into a problem in law. So if we take an example here, if we're given a factual problem dealing with a man who's talking on his cell phone while he's driving his car and he crashes into a motorcycle, we take that set of real-world facts and turn it into a legal issue by asking, was the man driving his car negligently? Each mooting problem will give you between 2 and 4 big legal questions that you have to answer in the course of your argument, and each speaker tends to take 1 or 2 of these. But those are not the kind of issues that I'm talking about here. The kinds of issues that I'm talking about are within those subsets of questions that you get. Within each of those questions, you have to explain what are the 3 or 4 main legal issues that need to be addressed. So that's then the issues. The more clearly and precisely you frame your issues, the better your argument's going to turn out. Once you've set out the issues, you then get to the L of ILAC. That is the law. Once we've explained what the legal issue is, you then set out and explain the relevant law. And this is where you would cite and discuss relevant pieces of legislation, case law, academic commentary, etc. In the example I just used, you would set out the legislative framework relevant to the question of negligence, if there is indeed any legislation. You'd also go on to talk about how courts have understood negligence through the cases over the years. Importantly, you would also want to set out the facts of the highly relevant cases, because indeed you may want to show in the next stage that your case is the same as a previous existing precedent. Once you've set out the law, you then get to the A. That is application. You end up applying the law you've just set out to the facts of your own case in the mooting problem. So you explain how the criteria you've just set out in the legislation or case law is met or not met by the case at hand. You explain why your case is similar to a previous precedent that you've discussed, or you distinguish a previous precedent. At the application stage, it's extremely important to recognize that the way you phrase facts, the order in which you state the facts, and the facts that you choose to group together can make a big persuasive difference to your argument. Finally, we get to the C. We conclude. Just as when you are writing an essay, your conclusion returns in a more nuanced way to the issues you set out in the introduction, you usually conclude your memorial by returning to the issues that you set out and showing how the law and facts that you've described answer the issues you set out for yourself at the beginning of the memorial. So, as a general framework, your answer to one of the main questions in a moot will proceed as follows. First, you have a paragraph or 2 breaking down the question at hand into 3 or 4 issues. You then go through each issue one by one. For each one, you set out the relevant law. Once you set out the relevant law, you apply the law to the facts, and then you conclude on that particular issue. At the end of dealing with all the issues, you'll have a couple of final paragraphs tying all the issues together to show why your answer to each of them collectively means that your client must win that part of the claim or moot question. Before moving on, let me give you 3 additional points about structure. The first is to say that when you're constructing an argument in the law, you should always ask yourself, what is the authority for this claim that I'm making? Every point you make should have an authoritative source. Unfortunately, your own ideas don't matter very much in legal argument, including in courts and in moot courts. What matters is that there's a piece of legislation or a series of cases supporting what you say. This then leads us to the second point I want to make, which is that in setting out the law, you should work with the hierarchy of sources that applies in the jurisdiction in which your moot problem is set. Now, students from civilian legal systems sometimes have trouble with moots, particularly because they aren't used to reading lengthy cases and because they aren't used to relying on past judicial reasoning. It's important to spend some time reading up about the way that legal reasoning and decision-making happens in common law systems, because most mooting competitions tend to mimic common law legal reasoning. In particular, you want to familiarize yourself with the idea of the ratio of a case. That is the central principle that each case lays down and which binds future decisions. You also want to familiarize yourself with how facts are distinguished from previous cases so that you can either use or avoid past precedent. Now, in the common law system, the general hierarchy is that legislation is the most important source, followed by case law. So when you're setting out the relevant law, you want to begin with legislation, if there is any on the topic. But in any good mooting problem, that's not going to be the end of the question. The legislation is going to be ambiguous, or it's going to leave gaps. So you then turn to case law. You figure out how courts have filled in those gaps or how they've interpreted ambiguous terms in the legislation. Once again, if it's a good mooting problem, that's not going to be the end of the question. Some cases will go one way, some cases will go another way. And at that point, it's your job as a lawyer to show why the judges must be persuaded by your interpretation of the cases rather than by another. And it's at this stage that you may want to rely on some sort of academic commentary to show how academics have resolved the tension in the case law. The same applies for international law. You follow the hierarchy of sources as set out in Article 38 of the ICJ statute. So you first look at treaties, then you look at custom, then you look at customary international law, and finally the writings of highly qualified jurists. The third and final point to make about structure is that when you're dealing with authority against you, you have to do so openly and clearly. It doesn't help to shy away from cases or legal arguments that go against the point that you're making. What you have to do is confront those and show the judge why they don't apply to the case at hand or why they're missing something important. It's useless trying to hide away from it because the judge is likely to know about it and ask you about it anyway. So those are the points about how to structure your legal argument. I now want to move on to a brief note about how to structure your research in your arguments. As I've said before, most mooting problems are designed to test an unclear area of the law. You should never get a mooting problem where the law clearly gives an answer that favors one side of the argument and one team. So when you get a mooting problem, you'll have a general idea of the subject area that it's dealing with. So start by picking up a textbook by a well-known academic or a good publishing house like Oxford University Press, Hart Publishing, Cambridge University Press, Harvard, and read the relevant chapter. Usually the chapter will have some kind of a brief summary of the debate in the area. It will set out the cases on one side and the cases on the other and explain the difficulties associated with each interpretation. It will also refer you to other academic opinions on the debate. The trick is to follow these sources. Find the cases that are in your favor, read them. Find the cases that are cited in those cases and read those too. Go to the academic articles that are cited. Read them. Follow the cases and sources that they cite. It's no good to say, this argument is true in law because I found it in this textbook. You want the authorities that the textbook is relying on. Going through this process of digging deeper and deeper into the sources helps you to start compiling arguments that are in your favor and to start building some kind of a structured argument with them. It also helps you to see what authority is against you and what you're going to have to respond to. The more sources you cite, the better. Of course, you don't want to go overboard, but showing that 3 cases support your claim is obviously better than showing just 1 case. As you're going through the legal materials, you should be reading the factual problem you have been set over and over again, picking up new facts. A fact that may have seemed irrelevant to you before may suddenly take on new significance once you know what the cases are looking for. By the time you present your argument to judges in the oral presentation, you should know the facts in the problem off by heart. Finally, I want to turn to a series of practical issues with drafting. In the first instance, I can't emphasize enough how important it is to footnote and reference as you go along. Don't leave it until the end. You use abbreviations that you end up forgetting. You don't remember what page of an article or case something was on. You may not even remember where you got the argument from at all. And so it's important to keep doing that as you go through. It also takes much more time at the end. It's much more efficient to add references in as you're writing your argument. The second thing I want to say is use technology if and when you can. Programs like Microsoft Word and EndNote help you to formulate tables of contents as you're going along. They can help you to make bibliographies. They can help you to reference better, standardizing your headings and subheadings, etc. So use these functions if you can. But remember, importantly, to back up all the time, because technology is a good friend but a bad master. Thirdly, I want to say you should think carefully about the time frame for your final submission. Ideally, you should have a complete draft of your argument long before the deadline, at least a week, so that you can go through and check for errors and refine your argument. That will also leave time to do the final referencing and formatting. Don't make the classic Mooter mistake of racing to finish your arguments and your formatting minutes before the deadline. The second last thing I want to say is that each mooting competition is a little bit different, and the format for each set of memorials is a little bit different. So before you get on the process of drafting your legal argument, check for some good examples of memorials from past competitions to get a good sense of what's required of you. The final thing to talk about in drafting legal argument is the difficult issue of how to divide work amongst the members of the team. There are roughly two different approaches that you can take. One approach is to give each person a topic or issue, and that person works only on that topic for the duration of your drafting process. The benefit of that approach is that this person then gets to develop an incredibly detailed knowledge of that particular issue, which allows for ultimately more nuanced and sophisticated argumentation on that particular point. The second approach is to have team members rotating through issues so that each person spends a little bit of time researching each point. The benefit of that approach is that each person has some familiarity with all of the material, so that when you come to choose the people who are speaking in the oral rounds, every person can talk to each topic. The downside of this latter approach is that nobody's an expert on any topic. Each time a person takes over a topic, they have to spend a lot of time just familiarizing themselves with the basics. And by the time they're getting the hang of it, they have to hand that topic over to a new team member. So while it breeds familiarity amongst all team members with the basic issues, you don't get a sufficiently detailed argument. And this can lead to very superficial arguments in the memorials. So each side has its pros and cons, and it's up to you to decide which procedure is best for you and the team. So what we've discussed is the ILAC method of drafting your legal arguments. We've looked at some ways to structure your research in a way that makes sense in your memorials. And finally, we've looked at some practical problems with drafting. And I hope that leads you to some success in drafting your memorials for your mooting competitions, as well as in real legal argumentation generally. Thank you.